We're here for oral argument in case number 1CACV 18-0712 TMS Ventures LLC versus Teresa C. Zachariah et al. Counsel, please identify yourselves and who you represent at the beginning of your arguments. As we noted to you in the order, we'll do our best to record this, and depending on the quality, it will later be posted on the internet. Also, please keep in mind that we've read the case. Obviously we've read the briefs, we've conferenced the case. Each side will have 20 minutes. And so, but for both sides, go ahead, and because there's a cross appeal, go ahead and reserve as much time as you'd like for rebuttal. Also, for Mr. Manhart and Mr. Broadbent, we'll leave that up to you how you want to allocate your 20 minutes. With that, Mr. Frazier, you may proceed.
Thank you, Your Honor. May it please the court. My name is Eric Frazier on behalf of the Zachariah, Apple, and Harrison families. I'd like to reserve 5 minutes of my time for rebuttal. Under Arizona law, there are 3 ways to accept a dedication: government acceptance, a recorded plat, and public use. Here, the government declined to accept this dedication. TMS asked Paradise Valley to accept the dedication, and the town apparently declined. So TMS is stuck with the other 2 forms of acceptance, and it failed badly on both. On acceptance by plat, I think it's important to take a step back and think about this. The only evidence in the case is that out of the entire plat of 25 lots, only 5 were sold with reference to this easement. That's 1/5 of the lots. And of the most affected lots in this case, 22, 23, 24, and 25, it's in the chain of title for only 2 of them, 24 and 25. So this is the easy case on acceptance by plat. The vast majority of lots do not have this easement in their chains of title at all. TMS's theory is essentially that if any one lot out of the 25 lots on the plat has accepted or has this easement in the chain of title, then the whole thing is accepted. That is not the law in Arizona. On public use, no members of the public are using the driveway as members of the general public. The 2 neighbors, the Apples and the Zachariahs, are using it as their own private driveway on their own 2 lots. It doesn't matter that they cross onto each other's property.
But Mr. Frazier, what about the fact that they're clearly, the members of the public have used the Madrid Avenue, and doesn't that make it more difficult for us to decide this, because we have what would seem to be a clear dedication out there on Madrid Avenue, and it seems like you're wanting to draw the line there between that and this start of the roadway.
So this is the easy case for the doctrine of partial acceptance. The bits and pieces that have been used by the public, and including the government for paving San Miguel Avenue, are part of a separately defined and separately delineated easement with an expressly different purpose. So the easement itself tells the public what the purpose is. The purpose of, if you look at the reply brief at page 31, this is the map that has the 2 different colors, the pink area and the yellow area. The pink area is the width expansion easement. And the easement says the purpose of the pink area is, quote, to increase the width of San Miguel Avenue. There's a different purpose for the yellow area, which is the area that's in dispute in this case. The purpose of that area, the easement itself, says to provide for another roadway not shown in the plat. So the public has essentially said, yes, we'd like some flexibility on the width of San Miguel, but we don't want a new road. The town of Paradise Valley has said we're willing to pave and maintain a road that is slightly outside the contours of the originally platted street to take advantage of this easement. But we do not want the entirely new road. So this is the easy case for partial acceptance. Cases around the country recognize that the public, whether it's formally through the government or by public use, can accept just part of an easement. And those cases are much more extreme here. Those cases involve a situation where you might have a dedication for a 50-foot roadway that's a mile long, and if only 30 feet of the width are used, that's all that's been accepted. If only half a mile of the mile-long length of the dedication is used, only half of the mile has been accepted. And the landowner can then gate the rest of the length or plant trees in the rest of the width. If it hasn't been accepted, if the whole thing hasn't been accepted, then it's perfectly fine for part of it to be accepted. Judge
Mr.
Williams?
Frazier, question for you here. If I'm understanding you right, the expansion of San Miguel and the roadway that is the driveway between lots 22 and 23, your position is that is one easement, and hence your argument for partial acceptance. Your position is not that it's two separate easements. Am I hearing you right?
So I think our position is both in the alternative. I mean, I think the easiest thing to say is that they're separate easements. They're separately defined, separately delineated. They happen to be in one piece of paper that's recorded, but these easily could be two separate easements. And the fact that they were in one piece of paper in the recorder's office doesn't mean that they're a single easement. But even if you find that they are one easement, only the pink area in our brief, the width expansion, has been used at all by the public or accepted by the government. Paradise Valley has accepted and maintains a road that is in that little pink area. I mean, we're talking very small bits and pieces of the pink area at that. And it has declined to accept the yellow area. So this is an easy case under either theory. Either they're two separate easements, or if they're one easement, this is one of the most easily severable easements in history because it's separately defined, separately delineated, with separate articulated purposes. You just look at the easement, it's on page 144 of our appendix. It has specific different purposes that it articulates. It delineates them separately. So this is the easiest thing in the world to sever. But again, you don't have to sever it. You can say that they're two easements from the beginning. And it makes perfect sense why you have this doctrine of partial acceptance too. The public can say, we want the flexibility to have an expanded roadway. And the way that the town used this expanded flexibility is to, alter the paving a little bit so you can go around a ditch or, address the physical circumstances of paving a road on the mountain. And it makes perfect sense that the public, vis-a-vis the government and the general public using it, could say, we don't want a new 50-foot wide roadway in the neighborhood. This is turning back to public use. Public use is about public space where anyone can use the space to walk their dogs, ride a bike, drive a car. We know what a public road looks like. We know what public use looks like. It's people using the property as members of the general public. There is zero evidence of that here, zero. But the evidence that we do have is that the two landowners are using it to access their own driveway. It is inaccessible to the public. It is private. It is gated. It is locked. The general public cannot use it. It would be very surprising to see someone walking their dog up this driveway. It would mean they broke through the gate. To see someone riding a bike up the driveway, driving a car up the driveway. It's inaccessible. It's locked. The only people who have access are the two adjoining property owners and their invited guests. And again, the use limited to the two adjoining lot owners is not public use. You don't have acceptance when the use is limited to a small defined group of people, especially those that are adjacent to the property. It's like a private park with a key fob. You can have the immediate, you can have a condo complex that has a private park in there. And even if originally 50 years ago, somebody intended to dedicate it to the public, if the condo has built a fence and you have to have a key fob to get access to it, the public is not using it. It's only being used by the adjacent landowners, which that's settled law throughout the country. That isn't public use. No one is using it as members of the general public. I invite you to compare San Miguel. Yes.
Counsel, before you move on, I'm curious to know your thoughts on or what the record shows, or if there's nothing there, then your thoughts about the impact on lots 24, 25, or so, first of all, two parts. What is the legal status of those two bits and pieces, as you referred to them in the briefing, I believe, or those two slivers along the back of lot 24 and 25? What, in your opinion, is the legal status of those, being that there was a deed that referenced the easement? And then secondly, has there been any public use on the back of those two lots that would differentiate it from lots 22 and 23?
So I'll answer the second part of your question first, Judge Brown. There has been no use on the back of those two lots. The driveway that we're talking about ends before you get to lot 24 and 25. So that is undisturbed desert land. Nobody has used it. As for the acceptance, again, the easement can be partially accepted. So even if you find that 24 and 25 have been, that portion of the easement has been accepted, that doesn't mean that the remaining part has been accepted. It doesn't make any sense to say that lot owners 22 and 23 forever forfeit their property rights because their neighbors have something in their deeds. But even 24 and 25, what's in their deeds is a reference to the easement, not a reference to a plat, which is really what I think the law requires. But we didn't go in depth into that in our briefing because that's not necessary. 24 and 25 can't accept on behalf of 22 and 23, and the public has not accepted the bulk of the roadway, which is 22 and 23. So I want to make clear the little tail in 24 and 25 of this easement. Again, that has never been used. There's nothing in the record about there. I think it's undisturbed desert land. The bits and pieces that I was referring to are in the pink area, the width expansion of San Miguel Avenue. So those are two different things. And if you look at San Miguel Avenue and compare it to the driveway, there are lots of pictures in the record. There's a video in the record that we cited in our opening brief. This shows the right way to do things and the wrong way to do things. San Miguel Avenue was on a formal plat. So the plat was approved and accepted by Maricopa County. The developer did things the right way. He laid out the entire network of roads for the neighborhood. We showed that on page 29 of our reply brief, where you have the two adjacent neighborhoods side by side. There are half a dozen, maybe a dozen roads on there. That's how you make streets. That's how you make streets that become public streets immediately without having to wait for somebody to use them, without having to wait for somebody to do anything. That is how you lay out streets. And then when you sell lots, everything is automatically immediately accepted because everyone can look at the plat and see the entire network of roads. But a year after this developer recorded that plat, he tried to slip in a new road through the back door. That's what we're talking about here with the driveway. The problem for the developer was that it had already sold 7 lots under the old plat. So the developer could not amend that plat without getting unanimous approval from those 7 lots. So it made a wildcat easement here, recorded it in the recorder's office, and hoped for the best. Didn't put it in the chains of title for most of the properties on the plat. Now, the town of Paradise Valley, again, maintains San Miguel Avenue. It's a paved road. It's used by the public. It's accessible to everyone. There's no gates. You can see people walking their dogs, riding a bike, driving a car, whether or not they live in that neighborhood. That is what acceptance looks like. The driveway, though, is just that. It's a driveway used by 2 neighbors. It is not a public road. The touchstone of public dedication is the public. And I think that gets forgotten when you look through these cases. So this is a very, very archaic and unusual body of law. But the touchstone of public dedication is the public. Unilateral actions are not enough to accept for the public. That's why we require public acceptance. Where is the public in all of this? The government doesn't want this road. It is not on the neighborhood plat. The public cannot use it. It is inaccessible to the public. It's not a public road, and it's not a valid public dedication. Happy to answer any questions. I'd like to say a few words on the attorney's fees issue before I save the remainder of my time. Anybody have any questions on the dedication piece? So on attorney's fees, this is the fee award in favor of TMS. the touchstone of 12.1103, which was the only basis for awarding fees, is whether we had to execute the quitclaim deeds, and we did not. TMS did not win on any quiet title claims. It doesn't matter whether these could have been quiet title claims. They weren't. The only claims it won on were declaratory judgment claims. If you look at the judgment, there is no quiet title. The judgment is declaratory judgment. So Pleak controls here. TMS did not get what it sought in the quitclaim deed. It doesn't get the quitclaim deed. 12.1103 does not apply to declaratory judgment actions at all, and definitely not for public dedication or implied way of necessity, which don't transfer title and don't entitle TMS to a quitclaim deed. I'd like to restate.
Counsel, help me understand that a little bit better. You're saying, if I understand you correctly, that the quitclaim deed that was offered did not say anything about conveyance of quitclaiming, if you will, an easement by implication. It didn't say, in the alternative, or there was nothing like that. They didn't. Are you saying that it was not set up correctly to get fees on it based on an easement by implication?
So there are a couple different things, right? The quitclaim deed is not for an easement by necessity, which has a whole host of things. It goes away if there's unity of title. It can go away if the necessity goes away. But more importantly, more fundamentally, that's not what the court awarded. So we have to look at the relief here. The relief is not, you don't get any, there's no claim, there's no title, there's no deed that's transferred. And that's what Pleak held. Pleak held that you don't get fees under 12.1103 if you didn't have to sign over that quitclaim deed. TMS chose the relief it sought, and it didn't seek quiet title on these claims. It sought quiet title on other claims, and we should honor how TMS characterized its own claims. I'd like to reserve the remainder of my time for rebuttal. Thank you.
Okay, thank you. Mr. Manhart, would you like to go first?
Yes, please. Thank you. I'm Daryl Manhart. I represent TMS Ventures as the appellee. My colleague at Buse Gilbert represents TMS for the cross appeal, and I hope to save 3 minutes for them to address that cross appeal. I'd like to start with some technical issues. With respect to Appellant Harrison's Lot 24, the opening brief admits there is reference to the easement for roadway and its chain of title, admits that Arizona recognizes that as sufficient for common law dedication, and makes no common law dedication challenge on behalf of Harrison's Lot 24. Harrison has thus abandoned any challenge to the common law dedication. I'd also like to draw attention to a jurisdictional issue identified at page 41 of the answer brief. There's jurisdiction for an appeal only for parties aggrieved by a judgment, and only as to the parts of the judgment for which they are aggrieved. The opening brief says TMS has the same access via the implied way of necessity easement that appellants state they are not challenging. The opening brief characterizes the appeal as if taken to clarify what the law should be on common law road dedication, even though appellants say it won't change the access of TMS. Taking them at that statement, the argument of the opening brief is a request for an advisory opinion and an admission that appellants are not aggrieved by the ruling challenged. Accordingly, their appeal as to the common law dedication should be dismissed and only the fee challenge considered. If the court's going to consider common law dedication, though, it starts with two elements. First, the offer of showing the dedicatory intent, and two, the acceptance by the public. The first element, dedicatory intent, was found by the trial court and is not challenged in this appeal. That leaves the second element, acceptance. As for acceptance, appellants seek to make two arguments. First, they deny acceptance, and two, they alternately try to bifurcate the easement and try to argue that only part of the easement enlarging San Miguel was accepted and not the route to the TMS property. In the trial court, appellants did not defend on the same basis as asserted in this appeal. Please look at their summary judgment positions in record items 40, 100, and 138. Their position was the easement for roadway could not create a common law dedication because it was not formally accepted by the county and did not satisfy the statutory requirement to amend a plat. Please also look at their characterization of the issues to be tried in the joint pretrial statement, which governs the trial. Record item 150, the only thing appellants stated about common law dedication is on page 6. This is what appellants told the trial court to consider. Quote, plaintiff is not entitled to gain access under the theory of common law dedication or by reason of a March 1960 easement for roadway recorded by Phoenix Title and Trust, which was invalid because there was no approval of or acceptance by the then town of Scottsdale, City of Phoenix, and Maricopa County. It's the same theory that they proposed in their findings and their conclusions submitted to the trial court in record items 149 and 154, and in their bench memorandum to the trial court, record item 211. They did not make the arguments they make now challenging acceptance, and they certainly never argued the trial court could find acceptance as to part of the easement rather than in its entirety. Appeal Rule 13A 7 subpart capital B says the appellant is for each contention of its argument to state, quote mark, references to the record on appeal where the particular issue was raised and ruled on, end quote. They cannot do so. The trial court cannot have erred on a theory appellants never advanced. Now, on the arguments advanced, appellants still fail. As to acceptance, the Arizona law is that anything that shows acceptance can be sufficient. There's much, and it's set forth in the answer brief, but to try to go over it briefly here, the easement for roadway, well, Mr. Fraser talks about, I think, 25 lots. I think he's counting all the lots in the Stone Canyon East subdivision. The easement for roadway identifies 8 lots as burdened by it, lots 16 and 19 through 25. Half of those do have references in the deeds in their chain of title to the easement for roadway.
Mr. Manhart?
Yes.
I'm sorry to interrupt. Question here, and the same question I asked Mr. Fraser. Is the expansion on San Miguel and the roadway that is the driveway between lots 22 and 23, are those 2 easements or is it 1 easement?
Your Honor, our position is that it's 1 easement. If you look at the document itself, its title is easement for roadway. It's not plural easements for roadway. It's not easement for roadways. It's easement for roadway. The singular is described in the language leading up to the legal description where it talks about an easement. It's just a single easement. So our position is that it's 1 easement. It says it has 2 purposes. It does define one of the purposes as to enlarge San Miguel, and the other purpose is to provide that access from San Miguel up to what's now called the TMS property. But it's a single easement. And it was a stipulated fact, it's item 148 in the record before trial, that the town of Paradise Valley has accepted and is maintaining San Miguel. So part of the argument here is that, Mr. Fraser talks about trying to maintain both arguments, and I understand that, but the record really gives up the argument that San Miguel, the enlargement of San Miguel, hasn't been accepted. It has. It's stipulated that, well, the evidence showed that the road does exist in expansion areas defined by that easement, and the stipulated fact was the town is maintaining that road. So that can be sufficient right there to find that the easement's accepted because the bifurcation argument should fail. But there's also evidence here that while it's not in their specific deeds, both lots 22, the Appel, and 23, the Zacharias, closed their purchases knowing ahead of time of the existence of the easement for roadway. It's in their title commitment. And while the argument is that's not the same as acceptance, I'd like to point out, look at Evans v. Blankenship and Lowe v. Pima County. Evans v. Blankenship says a sale of lots with reference to a map or a plat, even if it's not recorded, is sufficient because it gives the grantee notice of the unrecorded document. It imputes notice for the person to find that. Lowe v. Pima County is one where it's kind of odd in that while a county did not formally accept a road and it was not specifically referred to in conveyancing documents, it was the county who was the proponent of a common law dedication there and argued that because in the conveyance documents, the width, I think it was 30 feet, but whatever it was, the width of the roadway was carved out of descriptions, even though it wasn't referred to as a road. And the court noted that the purpose of including a reference in the grantee's deed is to impute notice to a map or plat so the grantee, or otherwise the grantee would not be expected to search for it. I want to flip that around and say that, well, if the purpose is to give notice and it can be notice even of an unrecorded document. Here we have a recorded document, and while it's not specifically in their deed, both parties knew of it and accepted those deeds. That's the same rationale, really, for why it's when you let it be imputed. That's where a party wasn't even necessarily given the document, but has a reference to it, and they accept the deed. Here, with in the case of Mrs. Zachariah and their property, it's particularly or important in that while they were negotiating to buy the property, their realtor was in touch with what was then the mortgage holder on what's now the TMS property, who told that realtor, who passed it along to the Zacharias, that there was an easement across the property for the roadway, and gave them a copy of the document. The Zacharias were upset about that and tried to negotiate with their seller, and there's an email in the record back to their realtor communicating that the seller, I think it's Exhibit 228, that the seller said there's nothing they can do about the easement. The easement exists, there's nothing they can do about it. They chose to go ahead and close. Afterwards, that same person, it was Jeff Anderson, who had told them ahead of time, that foreclosure was completed. And there's a letter from him. This is after the Zacharias acquired their property, so they already had the notice before that. I'm sorry, I'm actually deviating from what my point was, but Exhibit 26, he told them again that there was an easement to the TMS property. Then it was owned by La Familia. He gave them another copy of it. He exercised the right to use it. He said, we have physical and legal access to the property. He politely told them that he was going to be showing the property to purchasers and that he expected to be able to use it. He did say that he would respect any of their property along the driveway, but he asserted that, and the Zacharias acquiesced to that. But back to my point, I guess I started from, was they closed this purchase knowing of the easement, and that's just as good as if there'd been a reference to it in the deed, because they had actual notice, not just imputed notice. Now, there's also substantial evidence that the roadway was accepted by use. I've already talked about, and I think it's conceded, the San Miguel expansion occurred and was used. Additionally, the evidence in the record show that several lots along there are necessarily using parts of that enlargement, so they have driveways that connect to San Miguel that cross over their neighbor's lot, and that otherwise it would be improper except that they're using that easement. Similarly, there was a septic line, I believe, that was shown servicing one lot but crossing over this expanded easement. With respect to lots 22 and 23, Appel and Zachariah, they didn't establish this driveway. The Zachariah house was built in 1971. It was 29 years old when they first looked at it. Photographic evidence put into the record shows that the driveway was established long before either of them acquired the property. They both are using parts of the other's land, which is placed within that easement area. Mrs. Zachariah even testified that she understood that she had a legal right to use the part that was on Appel's property, and Appel had a legal right to use the part that was on the Zachariah property. She also testified that there was no agreement between them. In fact, she said they had never discussed the driveway. So the only record is that they are using the driveway, which was acknowledged to be within the easement area, because they recognize that there's a recorded easement, a recorded document that establishes that easement. I know that Mr. Fraser's argument is that they're not members of the public, but I'd like to point out some of the cases in Arizona. Pardon me while I'm turning some pages here. If you go back to the source cases recognizing common law dedication, I'm going to mention Allied v. Pettit, Edwards v. Sheets, and Drain v. Avery. They all involved plats that all treated the entirety of what was identified to be dedicated as what was dedicated, even though the prior use seemed to have been less than all of what was described. Continuing on with other of those earlier cases, in County of Yuma versus Leidendecker, the court referred to the subject park as used by the householders in the subdivision as satisfying the acceptance by use easement. And in that case, it happened to have been a document that was over 40 years past its recording date before anybody was arguing that there was a park. Hunt v. Richardson acknowledged an easement can serve a limited number of the public, including those residing nearby. What does that mean if it does not acknowledge that in some circumstances, while the dedicator intended the road to be open for the public, the only members of the public likely to make much use of it are the nearby landowners? And look at particularly at Drain v. Avery. That involved a dead-end road. It ended at the Grand Canal. At least one of the plaintiffs was the property owner at the end on the east side of what had been identified as a public street on an 1895 plat. It was over 50 years later that the lawsuit was initiated, by which time the defendant on the west side of what had been identified as a street on that plat had planted trees, put up sheds, a fence, and other obstacles in the area for the road. The opinion describes those things as on the part of the road, quote, not used by the public, end quote. Nevertheless, the court found that the use of the part of the area designated was sufficient acceptance and said the public can demand the use of the rest of it when it's ready. Who else is going to use that dead end but the owner at the end and his invitees? Please also consider Collins v. Wayland. The opinion says an alley running down the middle of a block was regarded as a public alley, but the only use described in the opinion seems limited to the abutting landowners connecting to a sewer installed in the alley. Edwards v. Sheets says use by the purchasers of the lots and the general public constitutes acceptance. That should mean to include the purchasers as part of the public. Unless the opponent counters by showing the purchasers have some agreement among themselves, the use by a neighbor is still use of the land one does not own. So you have, and Pleak also recognized use by a neighboring subdivision was sufficient. So here we have Appel and Zachariah both bought houses that had a long existing driveway, knowing about the easement for roadway, continued using it, and testifying that each had a legal right to use the land of the other. No testimony of a permissive agreement or some other explanation. So I submit that they are members of the public using each other's, even if you were to consider just the route to the TMS property separate from the route around San Miguel. But unless you agree to the bifurcation, then there's no issue anyway. And I've already pointed out that they didn't argue bifurcation before, but they rely exclusively on out-of-state cases for that argument. And I'd like to point out that if you look at those out-of-state cases, there's kind of a theme or a pattern. The argument is that use by neighboring owners should not count, and arguing that the common law dedication may be accepted as to part and rejected as to part. But in those cases, the law isn't always the same as in Arizona. So just because something is showing, well, the point I should make if you read those cases is that in many of them, the law is different, and some of them require showing public use even when there's a formal dedication. And the reason they're concerned in those cases is because those states recognize common law dedication as imposing the property ownership and liability on the public. So they're concerned about taxpayer money. So they're very concerned with allowing, when you submit something to the governmental authority, to allow the government to decide we'll accept part or all of it. But in Arizona, there's no such concern. Pleak in particular cites to Champy v. Castle Hot Springs and Territory v. Richardson as recognized that in Arizona, if you have a formal dedication, yes, the accepting governmental body does undertake responsibility for maintenance and liability. But if you have common law dedication, while there's a right in the public to use the easement, ownership remains with the private parties. There's no responsibility of a governmental authority to maintain it or liability for it. So the concern expressed in those out-of-state cases doesn't exist. Yes, sir.
So, counsel, Mr. Manhart. So does that mean that if this is that the owners of lot 22 and 23 would be liable if a walker or jogger came and tripped and fell on this common law easement? That they would maintain all the liability, even so they would have to invite the public and they would bear those burdens. Is that correct?
Well, Your Honor, I would condition that slightly. there's an implied way of necessity is not contested. So there's going to be that issue you raise regardless of the common law dedication issue. But with the common law dedication, while the ownership will stay the same, if one slipped and fall, their suit would be against who's responsible or responsible for that easement area. And all three of these parties, or all of the parties rather, I guess I should say, who own the easement or own an interest in the easement area could potentially be defendants. So that could include, yes, the lot 22 and 23 owners and the TMS property as well. But that's going to be the case even with the implied way of necessity. I see I've run way down on my time, and I want to briefly touch on the attorney's fee issue before I give Mr. Broadbent at least a little bit of time, and I'll try to be really quick here. The opening brief really relies on footnote 6 of Pleat on common law dedication. But and while I think it's I could debate that, which I understand this court's not going to overturn the Supreme Court. But here the amended complaint count 2 is entitled for quiet title, pleads there's an implied way of necessity in that count 2, and requests an award of fees under 12-1103. The statutory demand letters all requested a quitclaim deed for an easement, for easement purposes only. While he's pointing out, Mr. Fraser's pointing out the judgment says declaratory, it's declaring what's requested in count 2. It is a quiet title, and the normal quiet title thing is you don't get a deed, you get a judgment declaring you own the land or you own the interest. ARS 12-1101 defines what an interest in land, or defines that a quiet title can be based on an interest in land. Here there is an interest in land, that's what was determined. That supports the attorney's fee award under 12-1103, and the implied way of necessity is not challenged, so that fee should stand. I'd like to give the rest of the time to Mr. Broadbent.
Thank you, Mr. Manhart. I'll be very, very brief. We think that our opening brief and answering brief establishes that we were entitled to award of fees under the Warner factors and the stated purposes of 12-340-101. But I think for purposes of today's argument, can actually be quite made much more simple. Ultimately, it's whether or not that anticipatory nuisance claim could have existed, but for the underlying easement and contracts. Importantly, it wasn't TMS who set that forth. It was appellants who defined that it existed based on the underlying easement and contracts. It is appellants who set forth that ultimately is the easement that was giving rise to the anticipatory nuisance. They didn't claim that we were creating a nuisance based on helicopter access or noxious fumes. They said the use of that easement would create a nuisance. That nuisance claim could not have existed but for the underlying easement, and it was, in our opinion, error on the trial court to not award fees to our client. And with that, I'll yield.
Okay. Okay. Thank you, Mr. Broadbent. Okay, well, back to you, Mr. Fraser.
Can you still hear me, Your Honor?
Yes, and I'd like you to address Mr. Manhart's position that certain issues were essentially waived, including that the bifurcation argument was never presented to the Superior Court.
Sure, Your Honor. So on the joint pretrial statement, if you look at the plaintiff's position, it never articulated acceptance by use or acceptance by plaque. So they're the plaintiffs in the case. It's their obligation to put forward their evidence. So at trial, it's very clear that both at trial and in the Superior Court's findings of fact, conclusions of law, this case turned out to be about use and plaque, because pretty early on, the plaintiff admitted that the government had never accepted. We are not challenging that San Miguel has been accepted. That's not in dispute. That the San Miguel expansion has been accepted. That doesn't mean that the driveway has been accepted. Paradise Valley didn't pave the part that's in dispute. It only paved the pink area. And so in terms of partial acceptance, what we're saying, and what we've said throughout the case at trial and on appeal, is that paving those little bits and pieces in the pink area does not constitute acceptance of the driveway. We never waived that, because that's been the focus throughout trial and the court's findings of fact, conclusions of law. The question is paving those little bits and pieces in the pink area sufficient for acceptance? It's not. And the legal doctrine why it's not is either because it's two separate easements, or partial acceptance. This is not an advisory opinion. The consequences for public dedication are very different from implied waiver. We might have to remove the gate because it would prevent the public from accessing. Public dedication is a public doctrine. I'd like to talk about this notion of actual knowledge, because actual knowledge, there's no case saying that knowledge of an easement is public acceptance of a dedication. It's not, there's nothing public about it. This was an exception to the title policy because the title insurer perceived risk of a public acceptance. Just like TMS's title insurer tried to find out, was this ever accepted by the public? The title insurer didn't say this is a public dedication. The title insurer says, I perceive risk, either that maybe somebody has accepted or maybe in the future somebody may have accepted. That doesn't mean that there's acceptance. Knowledge is personal. And the question is, what did you have knowledge of? You had knowledge that there was risk that somebody might accept, that maybe somewhere in the bowels of Maricopa County, the county may have accepted somewhere and we can't find that. That's what title insurers do. They try to account for that risk. It is, and I think there's an important question that you raised, Judge Brown, which is, who is responsible for maintenance if there's public dedication? Who's liable for claims of defective roadway design or injuries that occur on the property? Would my clients be responsible for paying property taxes on those portions? I think those issues are unsettled in Arizona. There's really virtually no case law on those issues in Arizona. You don't want to force a public dedication on the public when the government has rejected it. What we tried to make this point in our reply brief, that there's a lot of evidence here of this and then of that and of this and that. It doesn't add up to public dedication, because what really matters is, did the public accept this? We know the government didn't. We know that literally no member of the public is using this driveway as members of the public. If you look at the cases that were cited, like Allied and Drain versus Avery, those were typically acceptance by plat, not by use. And the acceptance typically was not in dispute in those cases. We covered all those cases in our reply brief. Most of them weren't about acceptance at all. They were about abandonment or other issues. So really what you have to think about here is, does getting this into the chain of title when it's not in the plat for a couple lots constitute acceptance, and does use by the adjoining property owners for their own benefit constitute acceptance by the public? We ask that you reverse the judgment and the attorney's fees award.
Okay. Counsel, thank you very much for these helpful arguments, and the court will now take this matter under advisement, issue a decision in due course. Have a nice day. The court is adjourned. Thank you.
Thank you.
Thank you, Honor.